how can you protect the client? The client has to be informed right away.
I have quite a bit of experience with this. I just recently had a long-term client of mine that was looking to purchase a mall, so a commercial property.
Yes.
Right? But that property had a gas station on it previously. What I like to do for my clients, keep a long due diligence period, and it keeps it open.
For example, it was 2 buildings. So I was selling a building, it was on Bayview actually, and had the entrance, had the hallway which one owner was owning, but allowing the other tenant from the other owner to go through the hallway and go to their apartment, right? So it was an issue for closing. Just what would you do?
Number one would be obviously to read that agreement thoroughly the first time, right? If there's something like that that's already stated and disclosed, I would bring that to my client prior to, number one, prior to signing.
Yes.
And then prior to waiving conditions.
Yes.
Hi, everyone. Welcome back to the Dhanju Law Podcast. On today's episode, we've got someone very exciting, someone with a lot of experience. We've got Rodica Iliescu. I'm going to let her introduce herself.
Thank you very much, Namni. It is a pleasure to be here in your amazing office, and I'm so happy to be a part of this podcast. I'm a real estate agent with Remax for more than 18 years, and I have quite a vast experience in commercial real estate. I have sold many large assets throughout Toronto. I work in GTA, and I would like to open myself to the knowledge I have, and also she has a lot of knowledge that she can answer to our questions that we have burning in our industry, actually, that we can help day-to-day operations and agreements and leases. This is very important for the public to hear that.
Thank you, Rodica. So I've got a few questions for you, and then we can kind of just get into it. The first question that I have, and I asked this from a lot of agents that I speak with. Have you ever had a client that's really been burned by fine print?
You have a great question here that absolutely has to be raised to the panel here, because we have many occasions that actually the clients, they are not even reading the entire document, and that is impediment for their transaction, and then later on they suffer financially, and they will be in a setback that can take them years to recover.
Yes.
And it's very important to have a lawyer. Like yourself, you are very knowledgeable, and you have to read the fine print. This can lead you from $10,000 to hundreds of thousands of dollars.
Hundreds of millions, I could say.
Hundreds of millions. It depends on the asset that you are dealing with. Exactly. And what can I say? From the beginning of the time when you have the agreement, the lease being drafted, you have to consult the lawyer. You cannot present any document without the consult of the lawyer, because once it's drafted and is in the hands of the landlord, tenant, seller, when you are buying, then it's very hard to come back. Then it says it's creating a gap in between the parties, and it's not going to be flowing properly, the transaction.
Yes, absolutely.
Yes, damage is big.
Absolutely. And from personal experience, I would say about 95% of new clients that come to me with a signed, usually firm APS. And at that point, and I can't do anything at that point. I can't make any changes to that agreement, right? We're just kind of stuck. So we rely a lot on people like you.
Yes.
To do that work, to do that negotiation, to get to that point.
Yes.
right? But every client, I always tell them, you should be engaging us from day one, like you're saying, from day one,
Day one.
right? Not when you're ready for closing.
Yeah. Even before you even draft any document,
Mhm.
you have to talk to the lawyer, what is the best for me?
Yes.
Because the lawyer always checks title, checks environmental, checks all these other items that they need to be checked.
Yes.
And with the city, work orders, or any other problem, encroachments, because you don't know. And then, so let's say it's an encroachment of the property that has a hydro line that's under, and then you don't even know, you cannot even redevelop the property. This is a big problem because then you have too many approvals, and it's gonna cost you hundreds of thousands of dollars to relocate that hydro line.
Yes, and it's not part of the budget.
It's not part of the budget.
Exactly.
Exactly. So, as well as goes with the environmental, also the advice, the knowledge, the professionals, you have to consult the professional, especially now. There are many power of sales today on the market, and you cannot have even a condition in order to obtain the property, to secure the property.
Exactly.
And the problem is, they think that, no, it's okay, it's good, whatever. But no, the problem arise from wherever you don't even know. So I had a case when my client purchased a property that's industrial, had 4-acre land, and different uses were prior to this film studio. So the lands were specifically in one area very affected. And he bought it as a straight up firm deal because it was, large purchase. But he didn't think of that because he didn't know, he was not aware about the environmental issues.
Yes.
And
that environmental could even be an issue.
Yes. He just took it like a joke.
Yes.
Like this. And then what happened, actually, it ended up to be very costly. So I would like to ask you, Navid, what would you do in this kind of situations? How can you protect the client? The client has to be informed right away.
Yes, absolutely. So, I have quite a bit of experience with this. I just recently had a long-term client of mine that was looking to purchase a mall, so a commercial property.
Yes.
Right? But that property had a gas station on it previously. Right? And we made sure that there was no firm offer. That's for sure. There was conditions and conditions, but we essentially, usually what I like to do for my clients, keep a long due diligence period, and it keeps it open, right? You don't have to rely on anything specifically. You can kind of back out with anything in the course of your due diligence if something comes up, right?
Yes.
So they did the ESAs. They investigated kind of, the extent of the damage caused by that previous gas station, right? And whether they would be able to build something new in that area, or whether it's even safe, right? And in that course of the investigation, they did determine it's not worth it because it's going to cost hundreds of thousands of dollars, number one, to bring that soil, right, that property back to the proper condition.
Yes.
And then on top of that, to develop.
Yes.
Right?
Yes.
So they were able to, exercise their right to back out because they were still conditional.
Yes.
If they had waived that condition and realized later that, it's going to cost us hundreds of thousands just to repair this area, they were stuck. Be stuck. Either they would have to do that, or they would have to just leave that part of the property be.
Yeah.
Right. But they wouldn't get the full use of it, the intended use of it. They were planning to redevelop.
Yeah.
Right. So my advice always is, number one, speak to a lawyer first. Right. When you're putting in, especially when you're putting in offers in the millions of dollars.
Yeah.
Right. But even if it's in the hundreds of thousands, it's still money. It's still a loss that you can incur. Right.
Yeah.
So just because, it's going to cost you maybe a couple thousand more to have your lawyer review it
Yes.
before it's firm,
And add on
but it's
the
going to
clauses.
cost you. Exactly. So add in all of those necessary clauses so that you have peace of mind,
Yes.
right? That the money that you're putting in is safe. That deposit that you've put in is safe,
Yes.
right? And then especially when you take title to that property, that you take title to it properly, right? You're comfortable taking title to it. You understand the implications of taking title to it, right? And you've made an investment that you're happy about,
Yes.
right? You're not on the other side of it thinking, oh no, what did I just do?
Yeah.
Right. Because I've had clients thinking that, like, oh, you know what, we're firm anyway, we have to close anyway, and they're not happy
Yes.
at closing.
Yes. Yes.
Exactly. Again, like I said, they come to me, it's already firm. There's only so much we can do. There's only so much we can get the other side to do, but they don't have to, right? They don't have to accommodate us at that point because the agreement's binding.
So, what do you think you recommend that these conditions should be on the offer?
Yes.
And if the client decides to take them, to waive them in advance, I think they should be on the document. What do you think? Because they should contact the lawyer in case to decide together
Yes.
if it's possible to resolve them, or maybe shorten the time. What do you think?
Yes. No, I mean, the thing is, the way that I practice is usually we ask for more time than we need.
Yes.
And then if we want to fulfill those conditions before that time and close earlier, we will.
Yes.
Right?
Correct.
There's so many transactions we've had close earlier.
Yeah.
Right? But you don't want to be in a situation where, you ask for 15 days to do your due diligence, which is not enough.
Yes.
Right? But you needed 30.
Yes.
Or you needed 45.
Yeah.
You want to be in a situation where you ask for 45 or 60 days and you only ended up needing 30. Because everyone's happier. Right?
So I have another question for you. In case, for example, so you discover along the way that there are other issues with the property because you are working and you're doing all this due diligence before even firming up the deal.
Yes.
So the condition is not there, the paragraph is not, the clause is not there to protect the client. What would you do?
So you're saying it's already firm?
No, before. It's just found out during the due diligence.
Yes.
And then there is something that you found out from the city or some outstanding order. And then what would you advise the client right away? How to approach this?
So the first thing I do is tell the client absolutely everything about what's going on. And then I usually provide a legal and a business perspective, right? Is it worth it for us to kind of just take it and keep going? Right?
Yeah.
Is it worth it?
Yeah.
Or the other thing that happens a lot is use it as leverage.
Yes.
Right?
As leverage.
You're still conditional. So use it as leverage.
Yes.
Right? Reduce your purchase price or get something else. Get that sort of other accommodation.
Yes.
From the seller. Right? Because you're still conditional. You can still walk away.
Yes. Yeah. Correct.
Right?
Correct.
So a lot of the times, because of I'm business minded, this is what I do.
Yeah.
Right? It's not just legal. Right? If it was somebody that was just giving a legal opinion, they would probably just say, you know what, walk away. It's not worth it.
Yes.
But I work with business people.
Yes.
I am a business person. I understand. Right? I understand that there's a certain amount of risk that someone is willing to take. Right? And everybody's different. Everybody has a different level of risk tolerance. Right? But I know my long-term clients, I know the level of risk tolerance that they have. So I know, depending on what comes back, depending on what issue we have or what maybe, new permits or approvals or variants we'd have to apply for, whether they're willing to do that.
Very good.
Yes. But even if we're willing to do that or not, that's not something we would necessarily tell the other side right off the bat, right? We would just use it as a, what? If you don't accommodate us, we're going to walk.
Yeah, we're going to.
They're trying to sell this property as much as we're trying to buy it.
You're a very good negotiator. Yeah, amazing. Very good. Very good. So I had another case. For example, it was 2 buildings. So I was selling a building. It was on Bailey, actually. And had the entrance had the hallway which one owner was owning, but allowing the other tenant from the other owner to go through the hallway and go to their apartment, right? So it was an issue for closing because didn't pop out before we were exposing all this information. I was on a selling side. I was a seller agent, but the buyer agent did not pick up this information, even though it was on a paper, was on an agreement. So it was a big issue at the end, but we closed, but they could have avoided probably different terminology of the clause. So, but it was stated. So I explained, I even took the agent there, but maybe it was not transmitted to the buyer. So what would you do in this situation? Because the cost was actually just $100 per month, was very little for this gentleman to access to his apartment, which is detrimental for redevelopment as well.
Yes.
Because you cannot do anything.
Yeah.
It's a passage.
Yeah.
He's
got no right of way.
Yeah, what's unusual. This is how some homes were built before, and probably was a family, and before was the whole family owning all the strip, and in time they got sold. But just what would you do?
From the seller side or the buyer side?
The buyer side.
The buyer side. I mean, number one, and obviously we can't go back in time, right? Yeah. Number one would be obviously to read that agreement the first time, right? If there's something like that that's already stated and disclosed, I would bring that up to my client.
Yeah.
Prior to number one, prior to signing.
Yes.
And then prior to waiving conditions.
Yes.
Right. You want to make sure, even if it is just $100 a month, again, it's not budgeted.
It's not budgeted.
If the client doesn't know, they can't budget for it.
Yeah.
Right. Yeah. So whether it's $5 a month, $100 a month, or $1,000 a month, it's still they need to know.
Yes.
They need to know. They need to understand everything financially, right? Because it's an investment, right? And it's a financial investment. So they should be fully aware of everything, every cost.
Yeah.
Before entry to that transaction.
Was the maintenance of that hallway, the maintenance actually was quite expensive. But not budgeted.
Yes.
They couldn't do anything. It was a contract for 20 years.
Oh my goodness.
Yeah.
Oh my goodness. Yes. I mean, there's potential sometimes, even it is firm, there is sometimes potential to negotiate something.
Yes.
Maybe come to terms, right? With the seller.
Yes.
Possibly. But there's no guarantees, right? Like that's kind of what we've been talking about this entire time, that once you're firm, you're firm. It's legally binding. Yes.
But what about, let's talk about the disclosure.
Yeah.
If the client, for example, so the seller does not disclose, certain things.
Yes.
In the building, for example, some structural that was just painted over and not actually addressed properly with a structural engineer. So what would you do when it was not disclosed and we find out after latent the fact that it had structural vertical damage because of the land that was moving, and it was more sand actually than soil. The concentration of sand was greater than the soil. So what would you recommend in that case after it's firm? So let's say between after firming up and to close, then you find out even the structural when they did the building condition report was not picked up because it was covered.
Yes.
But then later they found out to a neighbor, some incident.
Yeah, somebody.
So then what would you do in that case?
See, that's very different, right? Because if the seller is intentionally hiding this, right, that's very different from, let's say, if there were leaks in the foundation or there was mold under the floors, but the seller didn't know.
Yeah, didn't know.
Then it's different.
It's
right? Because then it's not visible to you. It's not visible to them.
Yeah.
Right. And nobody really knew in those cases, it usually, it continues. Right? Then they're not going to terminate that agreement. Right? But if it's something where they're intentionally covering it up, they're painting over it, they're making sure that the buyer does not find out. That's fraudulent.
That's fraudulent.
Right? That rises to a much higher level. Then there's grounds for terminating that agreement, right? Which would potentially go to the courts if it's not resolved between the parties or between the lawyers, right? Because that's a much higher, that's a big issue.
Big issue. Yeah, right. Because you don't know the extent of
and you don't know how they're hiding.
Yeah.
If they were willing to go out and intentionally hide something that big, you don't know what else they're hiding.
Yes.
Right?
Yes.
You don't know what else they're lying about.
Yes. Yeah.
Right? So in those cases, generally, I would advise my client to not do dealings with a seller like that.
Yes.
Right? Because if you can't, there's a level of trust that's required. And I always talk about this with my clients. You need to be able to trust the party that you're transacting with.
Yeah.
Right?
Yeah.
You need to be able to trust that the information that they're providing, the financials, the leases and everything, they're valid and up to date.
Yes.
Right? So if you have reason to not trust them, such as this, and, do you really want to continue?
Yes.
So even if it were firm, if it was something so serious as fraudulent, then the buyer could potentially get out of that transaction. Depends on the situation again. There's potential there.
You are responding so clearly and really as a professional as you are. Yeah, I'm very impressed and I'm really happy that we are here.
I really appreciate it.
I have another question about so for example, the property A and property B, the client wants to decide to buy whether A or B. So the property A is well maintained. It has a manager on site all the time. It's maintained everything inside with starting from HVAC to to plumbing and wiring, and then but it's expensive. So then you have a property B that is not well taken care of, really left in disarray. But he likes the other building because it has less, it has potential and he can make some money. The other upside. Yes. But property A doesn't have much of an upside because already was used up by the present owner to
bring it with
exactly.
Yes.
So, what would you advise this client to buy property B if he really wants to buy that property from the start?
So he wants to buy
the damaged one.
Yes, he wants to buy a B. Would I advise him to buy a B? Again, it goes back to the specific client's risk profile.
Yes.
Right? It's the risk they're willing to take.
Yeah.
Right? If this is somebody that's not so experienced, not sophisticated, I honestly would tell them to buy A. Because it's basically turnkey.
Very good.
Right? And there's not too much that they have to do, and it's a good learning experience, right? Everything already there. The property manager's there, which will likely stay.
Yes.
After closing, you can learn from them kind of, the ins and outs of the property, and then the next one B.
Yes.
You find something similar to B, right?
Yes.
But if you're experienced, if you know the industry, if you are willing to take that risk, absolutely property B, because there's an upside. You can, if you have the capital, you redevelop it, you fix it up, you bring it to a proper condition, you bring it to the condition of property A.
Yes.
And then you sell it.
For amazing answer. Wow.
Yeah.
Very good. Excellent. Yeah.
This is all I do. This is all I do. A and B.
A and B. That's because you're a businesswoman too. So it makes sense, everything you do. And that's amazing.
Yeah.
So I have another story about the yield maintenance fee, which I was not personally myself because I have buildings too. What is this yield maintenance fee and how it's calculated? Everybody's calculated differently and they pick up the bond rate differently how they want. So about this, when it's in a contract, you are not having a mortgage broker that actually is helping, and you come with a paper with a document already signed by the client. And what can you do then? It's not closed yet, but can you do something about it? Can you mitigate the damage? Because this happened many times. They just sign and then, oops, it's hundreds of thousands penalty.
Yes.
So we don't even know, like public should be aware, like they should have a professional reading the document before they sign.
Absolutely. Absolutely. And mortgage brokers, or, I don't want to say anybody in particular, right? But they're just trying to get you to lock in.
Yeah.
Right.
Like when you go directly to the bank or a mortgage trust, or you have to have, my opinion,
Yes.
a person, like a lawyer, to read that document. Don't sign, just read it before. Go and read the document along with the lawyer, because that will affect all these years of the term and can be a big expense. What do you think about this?
No, absolutely. I have clients push back all the time. They say, I'm arranging my financing from such and such bank or such and such lender. I'm getting my insurance from so and so. I'm doing everything, all of this stuff, and then I'll tell you when it's done. But they don't want me to review it because they don't want to incur the extra legal costs, right? But your insurance broker, your mortgage broker, your lender, they're not going to provide you with legal advice.
Yeah.
They're not providing you, the information that's in your best interest legally, right?
Yeah.
They may be working with you. You may know them very well. I'm sure they're very, very knowledgeable in their respective fields. But the entire context of the situations, right? You need a lawyer to get their eyes on that document and review it and make sure that it is in your best interest.
Yes. But the mortgage professional, when you go without the mortgage broker, usually directly to the lender, you are missing action here, and you increase your liability. Because the mortgage broker also advised to go to check whatever done with. But when you go directly, it's a bit different because it goes directly to the lawyer sometimes, but the late is late.
Yes. Well, it's at a point when they can no longer negotiate. Right? They get those mortgage instructions and we're pretty much closing.
So it's too late.
Yeah.
Can't do nothing.
Yes.
But can you ask any documents that are stated in that that mortgage agreement, that at least you have clarity and you know what is the liability for the I'm thinking even after you close, you should still come and know your rights.
Yes.
What do you think?
Yes. I mean, the way that I practice is I go through everything with the client before closing. It's not just a quick meeting to sign. Right? So we're going through all the documents. So whatever we're signing for the lender, whatever we're signing for their mortgage, we're going through it to make sure that they understand the implications. Number one, the implications, whether it's open or closed, right? Whether they can even prepay.
Yes.
Right.
Yeah.
Or what penalties are involved. Or whether, like insurance.
Yes.
Whether there's insurance involved in the mortgage, the cost. Premium. There's so many things, or like the way that it's structured. Right. Is it a home equity? How is it? Or is there some other collateral there? Who's guaranteeing it? Like these things have significant legal implications, and many clients have no idea. They have no idea what's going on. Right. I get it. I get this line all the time. Just tell me where to sign. Tell me where to sign and I'll sign it. I can't wait to, own this home or own this property, or I don't want to talk about it. I don't have time. Right. But you will have time later when you realize, what did I sign? What did I sign up for?
Yes, exactly. Right. It's a big issue. I'm just raising it because I'm facing, these issues that are actually very important. And the other day I had another offer for property that was power of sale.
Yes.
The client has his own lawyer, But there is now a legislation about HST that if you renovate this property completely to the bond, to the studs, then HST applies.
Yes.
And I was surprised. My client didn't know about that. And I said, maybe you should check more and find out more information about this, because then you end up buying it and you pay this HST on top of it.
Yeah. Which could be significant.
Significant.
Yeah.
Yeah. So that's another topic that, people are not aware, but they have to be knowledgeable again.
Of course.
I mean, my opinion is to consult a lawyer before you want to have any transaction, because you have to be protected.
Yeah.
You cannot do anything without, because today it's a litigation world.
Yes. Very litigious.
You have to be aware of what's coming. You have to know your rights.
Yes. And the kind of tying into that, as a client, right?
Yeah.
Clients aren't expected to know when the law changes,
Yes.
right?
Yes.
They're not the ones that are sitting there day in and day out reviewing the changes in the law.
No, you can't.
We are.
Not knowledgeable.
Yeah.
No knowledge.
Yeah.
And even though you know that you understand what's written, but still behind it, the meaning is different.
Yes.
For us, I'm not a lawyer and I cannot advise this information. There's no way. But I can point something is wrong and I have to address right away.
Exactly.
Yeah. Like with this HST, and I said it right away. But, because I know, I read.
Yeah.
I'm,
Exactly.
10 courses, but it's different. Not everybody does that. So you are exposed.
Which is why exactly you want to work with a really experienced real estate agent like yourself.
Yes.
Right.
Thank you. And you do? Experienced lawyer and businesswoman, which is a perfect pair.
Absolutely, especially for the line of business that I'm in.
That I can hardly wait to work together. It's really amazing. You're amazing lawyer.
Thank you. I really appreciate it. And it's been a pleasure getting to know you.
Yeah.
Getting to hear about all of your experience. I mean, I think we could sit here probably all day and you would have another story and another story.
Yeah, every day it's another story.
Yes. I mean, it's so many. But that's how we literally learn, right?
Yes.
Those experiences, now I know for the next one.
Yes.
Right? I had a client that dealt with this.
Yes.
And so that experience helps me to guide, my clients going forward.
Exactly. Exactly.
Yes.
That's amazing.
All right. I mean, it's been so much fun, but I think we're kind of right at the end of our time here. So we're going to wrap it up. Thank you so much for coming on to our podcast today and talking about things that are so, so important for clients, for potential clients, for anybody that's out there that's watching. Absolutely reach out to Rodica if you have any questions, anything that you want to pick her brain about. She would be more than happy to have a conversation with you or even represent you in a transaction. All right.
Thank you very much. Thank you, Navneet. This is a pleasure, such a pleasure, really, to be in your podcast. I am really grateful. Thank you. And you are amazing, professional, as I said, and businesswoman.
You as well.
I encourage everybody to contact you and to get your guidance and to avoid many other aspects that are not meant to be.
Yes, absolutely. No, thank you so much.
Thank you.